Welcome to the case study of CCIG Investments Party Limited v Schokman. This is a recent case looking at vicarious liability and specifically scope of employment. The High Court of Australia decision in this case deals with the extent of vicarious liability in the employer and employee relationship, and their decision affirms that employers are not liable for actions of their employees if those actions are not within the course or scope of their employment. Ultimately, the scope of employment will turn on the facts of individual cases. And in this particular case, it is too simplistic to say that an employer will be held liable for the wrongful acts of an employee if those acts are committed in the course and scope of employment. So establishing whether a tortious act has occurred during the course or scope of employment depends on the circumstances of each case, and is informed by reference to previously decided cases. The attribution of criminal liability reflects the policy that the law, it would be unjust to make an employer responsible for every single act of an employee. So whilst an employer can be held vicariously liable for unauthorised or intentional or even criminal acts of their employees, there are limits to how responsible they are or when they are responsible. So the law proposes that the employer should not be held liable for acts totally unconnected with their employment. A wrongful act may be committed during employment, but what needs to be examined is whether that was during the normal course or scope of employment. And there's a wide spectrum that the High Court in this decision reinforced. They looked at anything from the common law act of a stranger, which includes circumstances when an employee does something so far removed from their duty that it's completely outside the scope of their employment, and as such has only a connection to employment in that they actually were employed at the time of the act, but has nothing to do with their actual employment, or acts of an employee who, because of the special nature of their role, actually obtained intimacy and power in that situation. So the High Court looked to the precedent of Prince Alfred College Inc. v ADC, a 2016 High Court discussion which involved an employee who was placed in a particular position of authority, power and trust in relation to a vulnerable category of potential victims. So they were the boarding school master who had responsibility of the boarding students, and so therefore their employment gives them the occasion for the wrongful act and is therefore regarded as being within the scope of their employment. So let's look at the specifics of Schokman's case. The background to the case is that Mr. Schokman was an employee of CCIG Investments on Daydream Island in Queensland, and it was a condition of his employment that he was required to live in shared accommodations provided by the employer. At the time, Mr. Schokman was sharing accommodation with a fellow colleague, Mr. Hewitt, and he was Mr. Hewitt's manager. On the 7th of November 2016, while Mr. Schokman was asleep in his accommodation, he awoke to find Mr. Hewitt urinating in his face, causing him to inhale and choke in a distressed state. As a result of this incident, Mr. Schokman suffered an exacerbation of his pre-existing sleep disorder and developed cataplexia, which is a brief loss of voluntary muscle tone triggered by emotional stress, and he brought a claim against his employer. Mr. Schokman also developed post-traumatic stress disorder as a result of an adjustment disorder. So Mr. Schokman brought legal action against CCIG Investments, accusing them of breaching its duty of care and that it was vicariously liable for the actions of the co-worker. In the first instance, the trial judge held that Mr. Hewitt's actions were not committed in the course of his employment, and although it was accepted that the employee shared accommodation provided the occasion for Mr. Hewitt's actions, the trial judge concluded that the employer was not on notice of any untoward behaviour on the part of Mr. Hewitt. It was then taken to the Queensland Court of Appeal, which allowed Mr. Schokman's appeal, and that court decided that the requisite connection existed between Mr. Hewitt's employment and his actions because the requirement to reside in shared accommodations was actually imposed in their employment contracts. This was then appealed by CCIG in the High Court of Australia, which allowed their appeal on special leave. In a unanimous decision, the High Court judged that CCIG was not liable for the actions of Mr. Hewitt. The High Court confirmed that the finding of vicarious liability requires the torturous act of the employee to be committed within the course or scope of their employment, and that making this determination will depend on the facts of each case. An employer will not be liable if the act was unconnected to the employment. On this point, their honours found, without more, the drunken act of urinating on another employee whilst they are asleep was not connected to anything the employee was required to do. The High Court found that the employer was not liable for the actions of Mr. Hewitt, as the untoward behaviour was not considered to be closely connected with any of their duties or powers of employment. The court observed that Mr. Hewitt did not have a special role over Mr. Schokman. It was held that the employer's power to monitor its employees did not extend to surveilling them during their leisure time or in their personal living quarters. The High Court clarified that for an act to be considered in the course of employment, it is insufficient to simply establish that employment created the opportunity for the wrongful act to take place. Their honours distinguish this from cases where the employee was placed in a special provision by virtue of their employment, such that it provides the very occasion for the impunged conduct. In terms of shared accommodation requirement, the High Court accepted that, at best, the condition provided only the opportunity by virtue of physical proximity only for Mr. Hewitt's actions, which was insufficient to establish vicarious liability. So the conclusions that we can draw from this decision is further guidance as to when companies can be held vicariously liable for wrongful actions of their employees. The mere opportunity for the conduct is not sufficient for finding of vicariously liable. The court reiterated that for the employer to be liable, the employment must place the employee in a position of power, trust and control over the injured person. This decision provides welcome guidance for the appropriate test to be applied to attribute vicarious liability to the wrongful acts of an employee. Answer the following questions to check your understanding of the case, to also think critically about how it should be applied, and perhaps create some study notes for a future use of this case as an example. Remember that we're all winners while we're learning, so keep studying, and my references for this case are at the end. Thanks.